evening. We've got two debates lined up for you in this edition of The Last Word. First, we'll pay attention to what's going on in Karnataka. And today, we will approach it from a different angle. We will ask the question, what can really be done in such situations, legally speaking, constitutionally speaking? Is there nothing that will stop the greed of these power-hungry MLAs? But here's a recap of what's happened so far. It was day 6 today of the drama that continued in Karnataka. The focus shifted from Mumbai back to Bengaluru again after the rebel MLAs who had been holed up at a hotel in Mumbai went back to Bengaluru to meet the speaker and again, this time in person, tender their resignations. All this after the rebel MLAs approached the Supreme Court and sought Supreme Court's intervention. And so the Supreme Court earlier today asked the 10 rebel MLAs to go back to the speaker today itself by 6 o'clock and convey the decision of their resignation. A bench headed by Chief Justice of India, Ranjan Gogoi, also in a way requested the speaker to take the decision on resignations today itself and then slated the hearing for tomorrow. But more political drama unfolded after Congress leaders blocked the BJP workers from entering Vidhan Sauda. BJP leaders had thronged Vidhan Sauda after the rebel MLAs arrived at the speaker's office. When all of this was happening, the speaker came out to give a media briefing where he clearly stated that he is not obliged to answer to anybody but only to the people of Karnataka, and that he will take his time to scrutinize the resignations that have been submitted to him. He will take all night if need be to go through these resignations. Speaker K.R. Ramesh clearly stated he will not take a decision in hurry and abide by the constitution that allows him this time. Meanwhile, Siddaramaiah has issued a whip to Congress MLAs to attend tomorrow's session to pass the finance bill and other matters. One wonders if this is even on their radar anymore. Governance, finance bill, important issues that matter to you, the citizens. So here is where the situation stands. We've got two big legal minds on our show today to help us understand legally if there are any options or if there is actually a need to bring in something. But before I go across to our panelists, here's an excerpt of that media briefing that the speaker held.
Have you accepted the resignation? Why are you delaying? I am delaying because I love this land. I am not acting in haste because I will have to convince myself. I am 70. I don't have to believe that I am going to live for another 100 years. But at least I must die peacefully. I said, I am repeating, I emphasize, I am not under anybody's obligation. My obligation is to the aspirations of people of the state and to the constitution of this republic.
Let's say good evening to Vikas Singh, former ASG, and Kailash Vaste, senior advocate with the Supreme Court. Mr. Singh, let me come to you first. According to the Congress and JDS party leaders themselves, this is the 6th time that attempts are being made, that MLAs have threatened to shift just in the last 1 year since this government has actually come to power. Before that, we saw similar drama unfold in Tamil Nadu, where within a year, at least 3 times, all of this drama happened to the extent of a trust vote, resort politics. What can be done legally speaking? Clearly, the anti-defection law isn't helping.
Well, as far as the present controversy is concerned, it is controlled by Article 190 of the Constitution of India, which talks of vacation of a seat by a member of the Legislative Assembly. Now, in this section, in this article, there was an amendment by the 33rd Amendment in the year 1974, and something very significant was inserted in this article. Firstly, it said that if the resignation is submitted to the speaker, it is not automatic. The resignation doesn't take effect on its own, and it has to be accepted by the speaker to become effective. That is number one. And the proviso also of that particular subclause of that article says that the speaker, before accepting the resignation, is to be satisfied that the same is voluntary and it is also genuine. So if he were to take a call that this is not voluntary, or if it has been induced by some, undue influence, etc., he can definitely not accept the resignation. Now that particular proviso which was inserted into the constitution definitely casts a duty upon the speaker to inquire the matter properly, and for that purpose he can definitely say that he will require time. Now this is the legal position according to me. But actually, if you ask me, the office of the speaker is being downgraded with passage of time, and people with sort of caliber and merit should come in as speakers, because speaker, being the party person, is normally towing the party line, and it is only interested in ensuring that the government remains in power. So that is something which is a very disturbing trend, and we should, according to me, come to a some kind of a consensus that henceforth the constitution should be amended, that a speaker should be somebody who should be completely independent. Speaker as well as governor should be somebody who is completely independent, because they perform quasi-judicial functions in such very important moments. And if they are to act fairly and independently, and if they were to uphold the spirit in which the constitution was drafted, then that can only be done if they are completely independent people. So that's the other, side of the spectrum, which also can't be lost sight of while considering a matter of this kind. And the proceedings of the speaker are immune. So really speaking, a court can't examine what the speaker is doing, and court can't control his behavior. So in that sense also, there is very limited scope for judicial review to say whether the speaker is acting correctly, or whether the procedure that he is following is correct or not, or whether you can bind him to take a decision immediately, or whether if he says he requires time to take a call, then whether the court can compel him to take a call. These are issues, which are very sensitive in nature, and I feel that the court should be very, very circumspect in, sort of forcing its views on the mind of the speaker, because the constitution as written today and as it exists today, I think the action of the speaker has to be given a certain amount of respect in taking a call, especially when the constitution has been amended and the speaker has been given
so there are two aspects, Mr. Singh,
role to decide on the acceptance of a resignation.
Right. So there are two aspects that you've raised. One, of course, is the role of speaker and governors themselves. And you're very right that I was going to say the same, that, often in the last 4 or 5 years that I can remember, I actually can't remember an instance where the governor was praised for the way the situation was handled. There was always a delay in action that led to further charges of horse trading and opportunities of defecting. So maybe these posts have to be insulated from all kinds of bias and politics. The second aspect that you raised, let me take that point across to Mr. Kailash Vastav. Mr. Vastav, what should be the court's role in this? Because the speaker has a duty. The speaker today in Karnataka came out and was very, very angry and said, I am going to take my time because I love my land and this is my duty.
Good evening. You see, the fact of the matter is this. We have got to look at this business of MLAs resigning, walking out, joining parties, merging, splitting, all sorts of words. This has been going on ever since horse trading is a part of politics. Horse trading is a way of life for politicians because that's where power is. And once you're looking at power, you will do anything to retain it. For the purposes of controlling this, in 1985, the 10th schedule was introduced into the Constitution. Apart from the existing provisions with regard to the rights of a member of the House, powers of the Speaker, they introduced the 10th schedule. In the 10th schedule, they had a clause in clause 3, which said that a party split would not amount to a defection. This was removed in 91. I'm presenting this to you to basically understand that whatever actions Parliament itself has taken for the purposes of preventing defection, they have defeated that by parliamentary action. Parliament must realize that when members are elected to the House, they're elected on the basis of a party and a representation made that the party would work in a particular direction. Of late, in the past 25, 30 years, parties are not working to their manifestos as they announce it at the time of the elections. They digress from them. They do not complete the work that they had assured the people on the basis of which they got elected. Now, it is here that the questions start arising. A, inability to deliver goods. B, hunger for power. C, power at any cost. We are at a position where we are looking at power at any cost. Defections have come to stay. The 10th schedule has been put in the dustbin. And in the working of the whole system, the judiciary is now being approached for everything. If you see Karnataka, you see Madras, Chennai, Tamil Nadu, you see Arunachal, you see Uttarakhand. I don't know, every state in the past 4 or 5 years has been in the Supreme Court for the purposes of retaining power and saying that the defections done are wrong, or a decision taken for the purposes of setting down a government is incorrect. The power of the speakers are sacrosanct. Parliamentary privileges, parliament powers, parliamentary debates cannot be set aside by courts. That's the position under the Constitution. In the present circumstances, the Speaker has the absolute power under the scheme of the Constitution and powers enabled to him to decide a matter at his discretion. No one can push him. Judicial intervention in 1965 was a matter which came up, contempt of the House, etc. Supreme Court said, look, let's keep off. The decisions here are the decisions of the House. We have a power for the purposes of examining a decision, but we have no power to set aside a decision until and unless there are certain considerations. So today, if the Speaker is going to take his own time, he will take his own time because he has to comply with the constitutional mandate to consider whether the member has acted under duress, under force, under pressure, or for considerations other than which are right. The court cannot possibly, my view, the court cannot and should not interdict the powers of the Speaker by asking him either to expedite the hearing or take actions which are within his or areas and circumvent them. The powers of the Speaker have to be respected and they must be respected.
So then how do we stop this?
Members of the legislative assemblies of parliament must respect the decision of the electorate. They shouldn't do what they are doing.
No, but then how do we stop this? I know what you're saying. In an ideal situation, Mr. Vasudev, that works. That everybody must uphold the dignity of their post and do their job as per the Constitution. But that's not happening. There are MLAs today who 6 months ago threatened to quit, were given plum posts. They didn't quit. Have quit again now and are constantly in negotiation with both sides to see who's giving them a better offer. It is happening so unabashedly that now the two parties are physically fighting over them, dragging them from one side to the other. Surely the politicians don't care about any dignity, any propriety, even the pretense of doing the right thing. They've given all of that up. So there has to be something.
You see, here is what Vikas said very rightly, an independent speaker or a speaker who is not having party biases.
Yes.
Sure, Vikas.
Yes, all right. Mr. Singh, you
no,
can
what
go
I was
first.
saying, because just for a minute.
Yeah, actually,
so therefore now you've got the
10th
10th schedule. Implement it.
Yeah.
Go ahead.
Actually, this is a method by which...
Hello?
Yeah, actually, this is a method by which you are trying to subvert the 10th schedule. If you see the statement of object and reasons for
That's
inserting the 33rd amendment or amending the constitution by the 33rd amendment, the whole purpose was that the resignation route was being used to destabilize a government. And that is why it was felt necessary that to uphold the values of the constitution and to uphold the democratic principles of governance, it should be necessary that the resignation should be considered whether it is voluntary and whether it is genuine or not. Now, if you see in a situation like this, if the 10 MLAs have just resigned without any justification, the speaker could be well within his right to say that the money has changed hands or whatever, or there are some definitely, there is some unholy nexus for this resignation, and accordingly the whole purpose was to bring down this government, and accordingly I will hold that it is neither genuine nor it is voluntary, because anything which is induced by sort of some kind of some benefit which is given, or some
Right.
advantage which is given to somebody to take a particular call, can be said to be not voluntary. So if this call is taken by the speaker, he is definitely well within his right to say that this resignation should not be accepted, and if it is not accepted, then they will be bound by the anti-defection law, and they cannot go out and support somebody else. So it's a tightrope for the speaker, if you ask me.
No.
And it's very difficult for the speaker to take a call in this matter, in a sort of time-bound manner, and he would be definitely justified constitutionally to take his time to find out whether he can say that this resignation is neither voluntary or is not genuine, and on those two grounds the resignation should not be accepted.
Okay, Mr. Vasudev, you wanted to come in. Go ahead, please.
No, go one step further. I want go one step further. Now there are 16 MLAs who've tendered their resignation. These 16 MLAs hold the government in balance. If the speaker is now going to take a decision that I do not accept the resignation, but their attempt to leave the party is a matter which calls for disqualification. So what's going to happen is either the resignations are not accepted or they are disqualified. Assuming either of the two things happen, there is no way that the government is going to fall, because disqualification means these 16 gentlemen have lost their authority to participate in the affairs of the House. They've been disqualified, they are out.
Right.
16 joining the party back, again there is no chance of the government falling. You see, but the fact of the matter is...
No, but in this case, Mr. Vasudev, I'm sorry I'm coming in there.
Views of the court.
But in this case, if the 16 MLAs do get disqualified,
Yes.
then the strength of the House comes down. And then the half
Then
of
the
that
strength of the House-
strength gives the edge to the BJP. Then JDS and Congress don't have the numbers to prove their majority and to hold on to the government anymore. So if they are disqualified or if they resign and walk away, either which ways the government will fall, can fall.
See, getting rid of 16 members from the House, disqualifying them, changes the whole
Absolutely.
demography of the House also, you see.
Yes.
The total numbers change.
Yes, exactly.
So if the numbers change, there is a chance that the government survives. So disqualification is a power which should now be used and effectively used by speakers, because that is only then that a sense of discipline will come in. This government has got a couple of years ahead of it. These gentlemen who are MLAs have looked forward to this term with a purpose. The purpose is to stay in power,
Yes.
whether it is this party or that. But if they're disqualified, let it be a lesson to everybody that this is not going to be the system which the Constitution envisaged or the electorate asked for. People who elect a representative look forward to the manifestos being implemented. Non-implementation is a right of the people to say, look, next time we won't vote for you. But here they're failing the people in the very beginning. They're entitled to go. They should go.
I believe they should go, and
Some
they should
strong
go
arm,
for at
some
least a
stern
certain
action
amount of
has
years.
now become mandatory in our system.
They should be barred from fighting elections even in the next term, until and unless we bring in perhaps a rule like that if you defect with the idea of getting more from the other side for your own greed for power, for toppling the government without there being a legitimate reason, then these MLAs should be not just be disqualified, but they should be barred from fighting elections for the next 5 years. That's my own personal view, but I'm running out of time, so I'm going to thank both of you, two great legal minds joining us tonight to help us understand legally from here on where can we go, and if there is a need to really bring in a new law, maybe relook at the Constitution, because what the Constitution gives us is an anti-defection law, which frankly hasn't helped us, whether it was the crisis in Tamil Nadu, whether it was the crisis in Arunachal, where again the top court had to step in, or in Uttarakhand, or now in Karnataka for the fourth, if not the sixth time. Something has to be done. to bring in some amount of discipline and fear in the minds of these greedy netas. And until and unless perhaps we set an example with some tough action against them, nothing is going to change. I highly doubt that expecting them to hold up the dignity of the assembly, of this democracy, is going to work. Thank you for joining us on debate number 1. We move on to debate number 2.